So the Supreme Court held oral arguments this morning in the New York State Rifle and Pistol Association v. Bruen concealed carry case. So let's talk about what happened and all the things that you need to know. But real quick before we jump into this video, if you think it's time for the Supreme Court to uphold our Second Amendment rights, go ahead and hit that like button and subscribe. Also, I want to thank everybody who jumped on the live stream with me this morning, who subbed to the channel, who also helped me reach that 200,000 subscriber mark. Thank you guys for all the support. I was amazed by all the support that you guys showed me this morning. And for those of you that missed the live stream, that is up on the channel so you can actually watch along with me and the rest of the community as we watch those oral arguments. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, the Supreme Court held oral arguments this morning on the New York State Rifle and Pistol Association v. Bruen case. This is a challenge to the state of New York's concealed carry scheme. If you need more information on what this all entails, I have tons of videos up on my channel discussing this very much in depth, all the various briefs filed by both sides, amicus briefs as well, to give you more context, but just understand this is a challenge to the state of New York's May issue scheme. So I'm going to dive right into the oral arguments and some of those things that popped up. First, I'm going to talk about the initial section, which was the petitioners, New York State Rifle and Pistol Association, and their arguments and the questioning that they received from the Supreme Court. So from the start, the petitioner side, the New York State Rifle and Pistol Association, made it clear that the state of New York actually had already conceded that there is a right to carry a firearm outside the home for self-defense. They conceded that point in their papers, and that was a big revelation, and that wasn't really hit on heavily in the oral arguments in the discussion because, again, the state of New York had conceded that. However, one thing that was talked about heavily was the fact that the state had shifted kind of that goalpost and made this issue an issue about carrying in sensitive places. The issue of carrying in sensitive places popped up quite a bit during the questioning, and so I want to mention that outset because there were a lot of justices who had heavily on those sensitive places and carrying concealed in those areas. So right off the bat, Justice Thomas asked the first question, which was really amazing. A lot of us had been anticipating that, hoping for that, and that happened immediately. Thomas asked the petitioners what history should be looked at. Maybe it's history during the founding, maybe up to the 14th Amendment. And the petitioners answered, yes, you should look at least at the founding, maybe up to the 14th Amendment, but maybe go no further than that. And then right there, what we saw is when Justice Kagan, Breyer, as well as Sotomayor, that's when they jumped in and kind of hit the petitioners with a onslaught of questions. Now, I know a lot of people were making comments in the chat during this period of time that the New York State Rifle and Pistol Association attorney was not doing a good job. I just want you guys to keep in mind that this wasn't his strongest section, but it is hard when you have clearly three anti-gun justices coming at you pretty much all at once. Now, Breyer's line of questions amounted to him saying that concealed carry is clearly dangerous, and if we let people concealed carry in New York and other areas, they will likely just get drunk and shoot other people. Those were some of the arguments he was making. Clearly not super strong arguments. They were very biased, and from some of these justices and their questions, you can clearly tell where their biases is. But I think there was a very strong retort to Justice Breyer's questioning in regards to that. Essentially, the petitioner's attorney said that, well, we have evidence from 43 other states that our shall issue allow a lot of people to carry concealed, let them exercise their Second Amendment rights to carry concealed out in public places, highly populated places, and we don't see them just shooting people all over the place. So the evidence indicates that what Breyer is hinting at just doesn't happen. Then there was some questioning from Kagan, and pretty much Kagan just adopted the state of New York's historical positions wholesale. And later you even had Sotomayor say that the petitioners themselves were making up history, which was really interesting, and I found that especially hilarious when later you had Justice Roberts point out how the Solicitor General themselves had blatantly left out information in a historical citation to meet their agenda. So that was just a very interesting thing where you had one side saying, hey, you guys are skewing history, when you had the other side blatantly skewing history and misciting things. Kagan also took the position that the right is treated different when at the home than outside of the home. And Breyer, Sotomayor, and Kagan appeared to take the position that the permit issued for hunting reasons in rural areas was sufficient enough. Now, after the bombardment from those three justices, the issue of carrying in sensitive places was asked by Chief Justice Roberts. Now, I will say here, I was very surprised and happily surprised by some of the questions that Roberts asked, and I think he came off more sympathetic to the Second Amendment than maybe I and other people thought he would be. Chief Justice Roberts asked if the state could restrict carrying in places like universities. Now here, I think the petitioner's attorney upset a lot of people, upset me as well by saying, well, yes, they could restrict in these places. And then there were a whole string of hypothetical places asked about, like the subway, Times Square, Yankee Stadium. These places are all being bundled into a so-called sensitive places restriction that the state may have a right to control. However, I want to make it very clear and important to note that this law is not a bar on carrying in sensitive places. This law is a bar on carrying in public generally for self-defense. At the end of the petitioner's opening is where Justice Kavanaugh and Gorsuch also jumped in. Now, Gorsuch asked about the lower courts and how they have been all over the map in applying the type of analysis when it comes to the 2A context. Now, this was really important, and I was really excited that Gorsuch kind of took on this issue. And this signals to me that a favorable Second Amendment ruling will have language reaffirming the text, history, and tradition as the appropriate type of analysis instead of tiered scrutiny. And why that's important is that bodes very well for a lot of us in other restrictive areas like the state of California, and would bode well for those jurisdictions in circuit courts who have applied different types of standards, tiered scrutiny. For example, the Ninth Circuit likes to use tiered scrutiny. Well, here, if you have the Supreme Court saying, no, that type of analysis is incorrect, all of you lower courts have been all over the map, no, you need to use this type of analysis, that bodes very well for the Second Amendment going forward. So like I said, I think the petitioners in their opening did a fairly good job. They stumbled a little bit. They had some issues at the beginning, but again, it's hard when you have the three left-leaning judges pretty much going after you. They had some redeeming factors at the end. But then in light of what happened after that, I think they looked a lot better, because then the questioning and the arguments moved towards the U.S. Solicitor General. And I think it was very clear from all of us who watched that and listened to that, that was a very beautiful train wreck to listen to. Now, in this section is where Roberts took up some of the questions, and I think he really surprised us with a lot of his questions and showed maybe where he is leaning on this issue. And again, he asked a lot of questions that are just very simple logic. He pointed to the fact that densely populated areas that they are trying to restrict carry are the exact type of places that people should be allowed to be able to carry, because those are the areas where people are maybe more likely to be mugged. And he even had this kind of snarky question that he asked the Solicitor General about, well, how many muggings happen in force? And a lot of people laughed in the courtroom, but it was just very clear where his leaning was, is that you need to carry concealed in maybe populated areas, because that's where you're more likely to actually need to exercise that right. And by restricting it to only maybe the forest or rural areas, that does you absolutely nothing. This logical approach was then also bolstered by Alito's questions, where he asked, well, shouldn't someone who works late nights in Manhattan in crime-ridden areas with high crime rates, well, shouldn't they be able to carry for self-defense? Shouldn't they be able to carry concealed? I mean, they're not having people saying, well, I'm going to mug you next Thursday, and then they can go to the agency and say, well, here is my proper cause. This person said I'm going to mug you on Thursday. Now, the Solicitor General's response to that is, even in those situations, no, these people shouldn't be able to carry. They shouldn't be able to carry even if they work at night in crime-ridden areas, maybe very dangerous areas. That's not good enough proper cause to justify them being able to carry. Justice Alito also asked, well, aren't there a lot of illegally armed people in things like subways already? So doesn't this law only prevent law-abiding people from carrying concealed and being able to protect themselves? And the Solicitor General's answer was very laughable. She pretty much just said, well, we have transit police who can protect people, so we don't need to worry about that. People don't need to carry concealed. We have the transit authority. So after the Solicitor General kind of stumbled her way through that argument section, which again, Supreme Court arguments are very hard. I would not want to do it myself. It would be very stressful and very hard. But I think we can all agree, out of all the individuals arguing today, this morning, that she did the worst. But after that, essentially it was the state of New York's turn. I think some of the more important questions that came out of this section of the arguments actually came from Justice Alito and Justice Gorsuch. Justice Alito asked some questions similar to what Amy Coney Barrett did. asking whether or not Heller had already decided and discussed a lot of these history issues and arguments that have popped up. The state representative tries to sidestep that by saying it was only determining the relevance of the history for that specific case. So that's how he's tried to sidestep that issue. He also was asked, and Justice Alito also asked, isn't it more important to look at the history and tradition around the formation of the actual text of the Second Amendment rather than cases or laws that popped up down the road? Again, the state says no, in their eyes, later laws or cases reaffirm what the founders intended, and they believe that that intent was to have restrictions on concealed carry. But again, Justice Alito kind of said, well, that's not how he views it. You can't use these later cases to kind of supplant the original meaning of the text. Gorsuch once again brought up the type of analysis that should be used, especially in light of lower courts and kind of them being all over the place. Here, on multiple occasions, you actually had the state concede that text, history, and tradition is the analysis that should be used and should be used by the lower courts as well, which that's a big deal. And I know I mentioned during the live chat, during that stream, that I think a lot of these lower courts went, oh crap, because a lot of their decisions are not based on the text, history, and tradition. They use a completely different type of analysis. Now, after this section was the rebuttal section from the Petitioner's New York State Rifle and Pistol Association. And I think here in the live stream, a lot of us agreed that this was the kind of high point for the petitioners. I think their rebuttal was very strong. He disclaimed a lot of those history arguments made by the state of New York, as well as the Solicitor General. I think in this section, the petitioner's counsel really hit his stride and kind of had a little bit of a mic drop moment at the end where he just pretty much torched all the arguments that were made by the other side and kind of walked off with that mic drop. So that's kind of how the main arguments closed off. Now, some of you may be saying, well, that's all good and dandy, but how do you think they will rule? Well, I personally think this will maybe be a 5-4 vote or maybe even a 6-3 decision in favor of 2A rights. Now, I also wanted to answer some general questions that I also saw pop up in the comment section after that live stream and also during the chat. So some people are asking, well, where is the decision? Well, the decision is not going to happen today. It never was going to happen today. That's not how this works. You will not get a decision until later next year. They have to write an opinion. It's likely going to be a lengthy opinion. There's maybe going to be concurrences, dissents as well. So you're not going to see that. That's not going to happen today. We don't know who's going to write that opinion, but if it was me, if I was a betting man and I wanted to put my money down on one of the justices, I would maybe say Kavanaugh. I think maybe Kavanaugh could write this opinion. Now, some people were also asking in the comment section in the chat, well, what impact will this have? The immediate impact will be on the state of New York. But generally, what also this will have an impact on is all U.S. courts as well, because this is the Supreme Court, and so any decision they issue has very overarching impact and effect on all other states' lower courts as well. So other states with may issue schemes and other circuit courts or lower courts who have issued a different type of analysis are at risk if the Supreme Court issues in a favorable light towards the Second Amendment. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos, in this type of 2A news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, hit the notification bell. Thank you to everybody who jumped on the live stream. All the support you guys have shown me is amazing, and I cannot thank you enough. I never thought I would be anywhere near this. I never thought I could live stream Supreme Court oral arguments or any type of oral arguments, and then 5,000 people would be jumping on it and watching along with me. So thank you guys so much for all the support. If you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and that really does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.